right, this is 25 CV 16784. Jill Bong versus Douglas County School District 15. I have this time set for a hearing to determine the sufficiency of answers and objections to request for admission. Is that what you all expect that we'll be discussing here today?
Well, Your Honor, I think that's what the hearing was noticed for, but I have a couple other matters that I'd like to raise with the court, given that we are 13 days from trial.
Okay. What are those things?
Number one would be this contempt proceeding that plaintiff apparently has initiated without any knowledge on my part. Apparently, the court has scheduled a hearing this Friday on that matter. I was not notified of that.
There is one. Hang on, I don't see one on the docket.
Okay.
Oh. Is it on the docket? Oh, there's a separate proceeding.
See, this is all news to me, Your Honor.
Hang on a second. Oh, I see 26 CN.
It's the 014.
Did I sign a show cause? Okay. I think, did that arise out of the, it is a part, okay, so wait a second here. I think that, okay, so go ahead, Mr. Merzero, because in my mind, I thought that, I don't think that I registered this as companion to the case that you're on, and I think that my understanding was that this was a case against Jensen for failure to comply with a subpoena, and my recollection was that you didn't have any objection in that space when I asked about the subpoena because you didn't represent Mr. Jensen or whatever agency he works for. And so I didn't, when I signed this, I don't believe that I caught this was a case that originates from 25 CV 16784. So, okay, so tell me what your position is.
Well, my position, as reflected in my filing, Your Honor, I filed a response to the complaint, the attempt to start a contempt case and the contempt complaint, and a declaration with that response that showed that I responded to the subpoena to Ms. Bong in November.
I don't know who this is against. Now, that's part of why I think there's some confusion. Is this intended to be? And I recognize that Douglas County is in the caption, but Ms. Bong, let me ask Ms. Bong, what is the intent of this complaint?
Yes, Your Honor, it is a related case, but the contempt proceeding is a totally separate case to this 8-4 case. The proceeding is against Mr. Jensen, the respondent. Douglas County School District 15 has no standing in the issue. It concerns Mr. Jensen not responding to the subpoena. And he has not responded. He has not contacted me at all. I have, in fact, sent the respondent courtesy copies of the complaint as of the filings to this case, even though I'm not required to, because that's a totally different proceeding.
So, Mr. Merzero, what I think I hear and what I think I thought, quite frankly, going into this was that despite the caption saying Douglas County School District 15, which is a oversight on the court's part, the contempt is directed at Mr. Jensen.
Your Honor, I do represent Mr. Jensen. I have always represented Mr. Jensen. He is the director of claims for the insurance company that is responsible for the defense of the school district. They are the school district.
What am I misunderstanding? What didn't we have? I think in the other case that has been, I think, disposed of at this point, there was a similar situation where there was a subpoena served and there was two of them, I think. And I think that my understanding at that time was that I thought that I got a representation from you that you didn't represent the parties, but you had no knowledge of the subpoena, and you objected to them on some basis previously. Does any of this ring a bell?
Well, it does, Your Honor. And of course, there are multiple interrelated cases here with the same parties.
Yeah.
And, frankly, I don't have a mental map of all of those cases in my mind right now and all of the stuff that was filed. But the important point is, and I don't know if the court can bring this up, but as I mentioned, I filed a response to plaintiff's complaint for contempt as soon as I received it. And that shows clearly that I responded to the subpoena on behalf of Mr. Jensen and provided a responsive
Well, I was going to
document.
get to that, but I wanted to go all the way back first. I think doesn't this demonstrate that that the point is moot, regardless, Miss Bong?
No, Your Honor. So I initially sent a subpoena to Mr. Jensen, I believe in November. And then I filed a motion to compel, which I did not file a copy to serve a copy to Mr. Mersrow. So to compel. And so I reviewed the motion to compel later on. I believe it was maybe in January or February when I did send a copy to serve a copy to Mr. Mersrow at that time. And in the February hearing regarding the motion to compel, Mr. Mersrow told the court that he doesn't represent either Mr. Zalisi, who was also another subpoenaed person, and he also did not represent Mr. Jensen. So as far as I know, Mr. Jensen has not responded to anything at all with regard to the subpoena. And I also served a courtesy copy of the contempt proceedings to Mr. Mersrow on, I believe it was March 28th or thereabouts, and the e-service shows that Mr. Mersrow opened that on March 28th. So his assertions that he did not receive it is not. I believe there's some reason.
Mr. Mersrow?
Well, Your Honor, the hearing on that motion to compel was about Mr. Zalesi's subpoena. As I recall, I did definitely tell the court that I don't represent him because he had another attorney that had already appeared in that matter on his behalf. But as you can see from my declaration, I responded in November to the subpoena on behalf of Mr. Jensen. I said to Ms. Bong, there is one document responsive to your subpoena. It's attached. I responded at the same time to a different subpoena that she served for which there was no responsive documents. So she has gotten a response. She has the only responsive document. I just don't know what we're doing here except creating more duplicative litigation.
All right. So
Your Honor,
how's that
in
not?
February, Mr. Mersrow
And I
was
see
very
that in
clear.
the original case. Go ahead.
Mr. Mersrow was very clear in February when he told the court that he did not represent either of the subpoenaed persons. That was Mr. Zalisi as well as Mr. Jensen.
I know, but okay. So did you get an email from Mr. Mersrow on behalf of Mr. Jensen?
I did not, Your Honor. To my knowledge, that was whatever he sent was on behalf of the respondent. I've not received anything from Mr. Jensen. And this is the first time I'm hearing from Mr. Mersrow that he represents Mr. Jensen as well.
Did you receive an email from Mr. Mersrow on behalf of Mr. Jensen responding to the subpoena?
No, I only received something from the district. I did not receive anything from Mr. Jensen.
Not from Mr. Jensen, from Mr. Mersrow. Ms. Bong.
I'm sorry, I do not understand.
So
I
Mr.
received something
Mersrow-
from Mr. Mersrow. He was representing the district, and the district has no standing to represent someone else, Your Honor. There was no indication that he was
Whose email
representing.
is Mars
Jensen.
in motion?
That's Ms. Bong.
That's mine.
Okay, there's an email attached here, November 16, 2025. that is to you. It says subpoena response. It says there is one document responsive to your subpoena to Jensen attached. There are no responsive documents to your subpoena to Miss Waleka. Walekala. I'm not sure how to say that name.
Yeah,
My apologies if I didn't get that right. Did you receive that email?
I took that to be Mr. Mesro responding on behalf of the district, because that email that he sent
Okay.
was between Jensen and the district. So as far as I am concerned, until today, Mr. Mesro has never told me that he represents Mr. Jensen, and he said in February that he did not represent Mr. Jensen.
Well, did you think that the district was responding out of kindness regarding Mr. Jensen with respect to the subpoena?
I have no idea what. I do not know what Mr. Mesro intentions was.
Is there anything else that's responsive to the subpoena that needs to be provided, Mr. Mesro?
No, there's not, Your Honor.
Okay. So, Ms. Bong?
Yeah. What is your question, Your Honor?
Well, he's here in the capacity representing Mr. Jensen, and is saying that what you've been provided with is all that exists that is responsive to your subpoena.
I think we should talk about it on the hearing for, I believe it's on the 8th. Today's hearing is regarding the sufficiency motion, Your Honor. I have not prepared anything for the contempt hearing.
Well, what else is there going to be to talk about?
Whether there's anything else, I don't know. As far as I know, as far as I've been told, Mr. Jensen was not represented by Mr. Mesro. That was in February, after that November email.
That's different now. Regardless of whether or not that is even true, that's different now. And he sent you an email. Is there something you're anticipating is going to change between now and Thursday that will show that Mr. Mesro or the district or Mr. Jensen is in receipt of documents that are responsive to your subpoena?
I believe Mr. Jensen may have other documents, because when I spoke to his attorney representing Pace, they told me that they had documents. So I do believe that there are more documents.
Has filed a declaration that says, on April 30th, I was served with a subpoena and other documents attached. Here's Exhibit 1. I am employed by defendant's insurance carrier and have no role in public records requests process used by the defendant. I have no knowledge regarding any of the issues raised in plaintiff's complaint in this matter. I cannot be present. Oh, this is to appear. Is this to appear remotely?
No, that's
that's the motion to quash.
Yes.
Yeah.
I've not had a chance to review that yet, Your Honor.
Yeah, I'm telling you what it says, though. And then Mr. Mesro filed a declaration. It says, attached here as Exhibit 1 is a subpoena directed at Joe LaFontaine, the superintendent of the defendant school district. The subpoena has not been personally served on Mr. LaFontaine. And it goes on to say, plaintiff has conducted almost no discovery in this case. She has issued a number of subpoenas to third parties and has filed 2 requests for admission. She has not served defendant with any request for production and has not taken any deposition.
I fail to see the relevance of that, because one, Mr. LaFontaine is an officer of the party involved. I do not need to serve him personally. I am allowed to serve him under ORCP 9, under ORCP 55. And I don't see any rule that requires me to complete RFAs or RFPs or depositions before filing a subpoena for trial.
What's the basis for the motion to quash, Mr. Mesro?
Well, there are 2 subpoenas at issue, Your Honor. Number 1 is to Mr. Jensen for his personal appearance at this trial, which he has absolutely nothing to do with.
On Thursday?
No, this is for trial on
Monday.
Monday the 18th, a week from coming Monday. So that's the basis for the motion to quash the subpoena to him, is that he has nothing relevant. And if the court will recall, Ms. Bong has repeatedly raised the issue of whether or not I am entitled to represent the defendant in this case.
I'm not worried about that.
Well, that's the only issue that she could possibly use Mr. Jensen for.
That's entirely speculative, Your Honor.
He has no relationship with the school district other than to serve as its insurer.
Okay. I'm asking you, as the representative for Mr. Jensen and for the school district, is there anything else that is responsive to the, I imagine it's a subpoena ducis tecum?
No. Well, yes, it is. To Mr. Jensen's subpoena is a subpoena ducis tecum, and the document requests are what. Actually, you know what, Your Honor, I don't have. The subpoena says Exhibit B. I don't think I have Exhibit B. I don't know that it was actually served on Mr. Jensen, so I don't know what the document requests are.
Okay.
I have the subpoena, I have a check, and then I have the contempt complaint, but that's it. The other half of this motion to quash is the document requests for Mr. LaFontaine. Now, Mr. LaFontaine is the superintendent of defendant. He will be present at trial. He will be the primary witness at trial for our side of the case, but the document requests for Mr. LaFontaine, again, clearly indicate that plaintiff intends to raise this issue of whether or not I am entitled to represent the defendant at trial or in any capacity. And the other part of this are essentially what our discovery requests in relating to the public records request that defendant made. The problem with that, Your Honor, is we're going to bring the documents the morning of trial. How are they going to be used in the trial if plaintiff sees them for the first time on the morning of trial? This is not a normal way that you would do discovery. I don't see the usefulness of providing her documents that come too late to be of any use.
I don't know about that. I've had trials where I've subpoenaed records that I didn't see them for the first time until it was in trial. So I'm not going to say no on that basis. But if there's no relevant information, that's another question. Are you saying there's no relevant information?
For some of the requests, absolutely. So this is Exhibit 1 to my declaration in support of the motion to quash.
I gotta find it because now I'm back in trying to. Okay, this is in 25 CV 16784.
Yes.
And when was this filed?
Filed over the weekend. I believe it was accepted yesterday, Your Honor.
5-3. Your declaration of Merzero. Okay. All right. Okay. I have it now. Okay. The civil subpoena. You're hereby. Okay. See attached Exhibit A. Documents to bring and produce. And then that's the end. That's the end of it on this. I don't see exhibit. Is there another exhibit supposed to be attached?
No, Your Honor. This is the exhibit.
Okay.
That is Mr. LaFontaine's subpoena.
Okay.
As you can see, requests number 1 and 2 and 3 relate directly to this issue of whether or not I am entitled to represent defendant. So the first
request 1. All records, including all paper records, hard or any other entity providing or administering legal defense coverage relating to. So I don't know. You're saying that request is related to whether or not you're entitled to represent them?
Well, if you look at A and B, Your Honor, those are 2 completely separate lawsuits. She's asking us for records relating to legal defense coverage provided by insurance in 2 separate lawsuits, not this one.
I guess part of the hesitation is, Ms. Bong, I don't know what the basis for those request would be other than what Mr. Merzero is asserting. So is there some other basis for why you're asking for those records?
Firstly, Your Honor, I have not had a chance to review the quash motion, so I do object to this hearing at this short notice. This was supposed to be a sufficiency motion, but those records were concerned the public records request itself. The issue is that Mr. LaFontaine asserted that he had no knowledge of these records, so that's what I'm requesting. Whether they searched
How does
for
that have to do with the administration of legal defense coverage?
That's Mr. Merzero's assertion. I do not know what he's.
That's what you put in the subpoena, unless somebody else put this in here.
I have to go back and review, Your Honor. I have not had a chance to review this.
Well, go review it.
Motion.
It's Exhibit A to your subpoena, I think. Is that right, Mr. Merzero?
Yes, that's right. The subpoena to Mr. LaFontaine.
Okay. I'm just making sure it's not something you...
Not been able to prepare, Your Honor.
Huh?
I object to this. I have not been able to prepare this. I have not had the chance to prepare.
I understand that you haven't been able to prepare, but the problem with that is that you're the one that prepared the subpoena, and all I'm asking you is, what are you asking for, and how is it related to the case? So I don't know.
I have to go back and
what
look
you
at
need
it.
to do to prepare.
I have to go back to look at what
it.
I requested, Your Honor, because at this point in time, I've not gone back. It's been a while.
Then go look at it, and I'll wait until you do that.
All right. I'm sorry. Bear with me. My files are here.
All right. Do you have the document, Ms. Bong?
I'm sorry, Your Honor. I'm still trying to pull it up. Okay, so I asked for the two cases, and
okay. So what are you asking?
So these two requests mirror the exact public records request in the case. And so I requested DC 15's request to pay to any other insurer for defense coverage. So this is the exact public records request that I asked for. So they claim that they have no knowledge of having the records, and that ended the matter. Therefore, it goes directly to whether the records actually exist and whether they're actually in the district's possession, custody, or control, and whether they conduct an adequate search before denying the request. This is not a side. This is not a side issue.
How does that have to do with the administration of legal defense coverage? How does that have to do with the administration of legal defense coverage?
So any documents that they had was would be pertaining to my public records request itself, Your Honor.
I guess, okay, Mr. Merzero.
These two requests, Your Honor, have nothing to do with the public records request process that is the subject of this case. These two requests have
the calculation of the fee, Ms. Bong?
No, this is not a calculation of fee question, Your Honor. They claim they don't have the records itself. So the issue is whether they actually. Oh, actually, they said they have no knowledge of having the records. So this case is about whether they actually searched for it and whether they actually have it.
How? Okay. All right. What is this case about? Let me go back and remember that.
This is a case where Ms. Bong made a public records request for documents that we do not possess, and we told her we did not possess them. She doesn't believe us.
Any and all records reflecting requests by Douglas County School 15 and are to the property and casualty coverage for education and other insurers for legal defense coverage. So this is related to the actual public records request, right, Mr. Merzero?
Well, and as Ms. Bong stated, these were the public records requests that she made, at least number one.
Yeah.
But
so why wouldn't she be entitled to that under this particular case?
Because the subpoena, Your Honor, has to ask for relevant documents. I mean, if it would be easier, we can just say that the district doesn't possess any of this again. But the problem is if you look at 1A and 1B under Exhibit A, she is asking for documents that relate to two entirely different lawsuits, Your Honor, not this one. These documents have nothing to do with this case other than they were the same public records requests that are at issue in this case. But this case is about the records request process. This is an Oregon Public Records Act case. These two documents have nothing to do with the process of responding to a public records request.
So she's asking for a declaration that your client violated Oregon public records law by improperly withholding, and an injunction compelling respondent to conduct a thorough and adequate search for responsive records and to produce immediately all records responsive to the request or specific statutory exemptions. So I'm not sure I understand the idea about the process. What are you saying she's asking? It sounds like she's asking for these records, and then through the case, she's issuing a subpoena asking for the records. And if they do exist, they need to be given to her.
Of course. If they existed, we would have given them to her in the first place, Your Honor.
Yeah.
We don't.
So I think I hear you saying we don't have them.
Yes.
Okay. So what's the issue here? What I mean, they don't have them. Ms. Bong?
The issue is, Your Honor, that the attorney for Pace or the insurer told me in the federal case that they do have those documents.
Okay, that's
In
your saying.
potential settlement talks, they told me that the insured has those documents. So my point is that the school district did not properly search their records or contact the insurance for those records.
All right. I don't know. What are you asking me to do, Ms. Bong?
I'm asking the court to.
This is a motion to quash. What are you asking me to do, Mr. Merzaro?
What I'm asking you really to do, the reason I filed the motion to quash, Your Honor, was to exclude Mr. Jensen. He has no connection to the public records requests that were performed by defendant. You're getting a little preview, Your Honor, here of what you're going to hear at trial in 10 days or so. Ms. Bong knows well that the school district has a 1-year retention of email. The documents.
We've been through that part. I know that.
Right. So the documents.
Okay, Mr. Bong has no Mr. Jensen has no relevant information.
Correct.
What's the basis for the relevant information, Ms. Bong?
Well, Mr. Jensen may have access to the documents I requested. I have yet to
He's filed a declaration.
prepare for my trial as well as for the quash. But however, no relevant information, Your Honor, is not a basis for a motion to quash. A quash does not allow for no relevant information as a reason, Your Honor.
What's
He
the
might
basis
have
for a
relevant
motion to quash
information.
then?
I'm sorry, Your Honor?
That is absolutely a basis for a motion to quash, Your Honor, that the witness or the discovery instrument, which is a subpoena in this case, has no relationship to the subject of the lawsuit. That's absolutely a basis for a motion to quash.
It is not under ORCP 55, Your Honor.
All right, I'll just read it.
It's actually ORCP 36, Your Honor.
I believe ORCP 36 is a protective order, Your Honor, not a motion to quash.
It is not ground a ground for objection that the information sought will be inadmissible at the trial if the information sought appears reasonably calculated to lead to the discovery of admissible evidence. I think I said that a year and some change ago about discovery. Okay, hold on a second. The court may quash or modify the subpoena if the subpoena is unreasonable and oppressive, or may require that a party who served the subpoena pay reasonable costs for production. Okay, so on the basis that there's already something filed that says that I don't know, well, let me go back to the declaration of Mr. Jensen again. Where is that filed?
That's also in support of my motion to quash, Your Honor.
There it is. Declaration of Jens Jensen. All right. I'm going to read the entire thing. It's not very long. I make this declaration on personal knowledge and in support of defendant's motion to quash. On April 30th, I was served with the subpoena and other documents attached here as Exhibit 1. I am employed by defendant's insurance carrier and have no role in public records request process used by the defendant. I have no knowledge regarding any of the issues raised in plaintiff's complaint in this matter. So if I go back to ORCP 55, and it says the court may quash or modify the subpoena if the subpoena is unreasonable and oppressive. But the part that's key about the oppressive part is that Mr. Jensen cannot be present in Douglas County on May 18th for trial in this matter. That day, I am committed to a long scheduled mediation in federal employment case, Medina v. Columbia River Fire et al., U.S. District. And then it has the court number. So it is oppressive, and it's unreasonable in light of the fact that he's saying, I don't have any information to contribute. And I know that that's hard to accept, that somebody can say, I don't have any. And if there becomes somehow, if something comes up at trial and it is in opposition to that statement, then I think we can deal with it in that way. But I'm not going to bring him here to just say repeatedly that I don't have something, when that's what effectively the defense has been. But Mr. Merzarone knows, and I can tell you this with confidence, Ms. Bong, that that if that turns out to not be true, there will be consequences for the respondent.
Of course, Your Honor.
Okay. Yeah, I understand. So, okay. So, and the contempt is in the same vein, isn't it? Is it not?
Yes.
All right. So is there anything else we're dealing with here today? The sufficiency for the answers, and then I'll give rulings on everything at the same time.
The only other issue, Your Honor, is there is a pending fee petition in the case that Ms. Bong voluntarily dismissed. That is 24 CV 52569. That is the case in which this court awarded a limited amount of fees. So if the court wants to deal with that without hearing, that's fine. But if the court wants to schedule a hearing on that, I'm welcome.
We will hear that before we have trial on the 18th.
Great.
So you all can be prepared to make arguments on that. Okay, so Ms. Bong, there's a motion to determine sufficiency of answers and objections to request for admission.
Yes, Your Honor. RCP
Are you there? You're probably, I know you're there. You're just breaking up.
number 31, 36, 38,
Ms.
39,
Bong,
40, and 41.
can you
Yes.
hear me?
Can you hear me?
All right. Yep.
Yes.
Go ahead now.
Can you hear me?
You were breaking up, but we can hear you now.
Okay. So this is a narrow ORCP 45 issue, Your Honor. The answers do not fairly meet the absence of request number 31, 36, 38, 39, 40, and 41. Denial, qualified answer, or detailed explanation. Respondent instead vague objections, remainder in denials, and arguments that do not answer the facts asked. For example, request 33 shows the problem. The request asks whether the respondent searched hard copy legal files or litigations in the record
Ms.
request.
Bong, you're
Then the rest
breaking up. Ms. Bong, you're breaking up, and entire
the
segments of your
privilege.
argument are going unheard. Are you there?
Okay, hold 1 second. Let me. Yes, can you hear me now?
I can hear you now.
Okay. So the respondent's answers to me is what 1. The rule requires specific admission, denial, qualified answer, or detailed explanation. Respondent instead uses vague objections, remainder denials, and arguments that do not answer the facts asked. Request 33 shows the problem clearly. The request asks whether respondents search hard copy legal files or litigation correspondence.
Ms. Bong, you're broken up again.
Answered that the litigation correspondence privilege. That may be argument.
Ms. Bong,
Can you hear me?
Well, yeah, you keep breaking up though. I have another matter that was scheduled to start at 2 p.m. I think because of the technical difficulties, the only thing that I can suggest we do is hear this argument at the time of trial when we had the attorney fee petition in the other case. As far as the motion, okay. As far as the motion to quash, it is granted on the basis that it is unreasonable and oppressive, and the complaint, the contempt case for the same matter, that there's nothing else to discuss, is dismissed. Okay.
Thank you, Your Honor.
Have a good day.
Your orders.
Yeah. Thank you. Have a good day.
Your Honor,
Come on
so
up.
is the court
Yes.
is the
Yes.
in the subpoenas were quashed, Your Honor,
I couldn't hear you.
other than Jensen's appearance.
The subpoena is quashed.
That's all right, Your Honor. Thank
Can
you.
you hear me? Okay. Have a good day.
Yes. Thank you.
Yeah.